Okay, good evening, everyone. It's 7 o'clock. Thank you for joining us, ladies and gentlemen. This is one of the advantages of Zoom, that we don't have to leave our homes in this cold weather in Johannesburg. So thank you for joining us online. Today, we're going to consider the question of land ownership and expropriation in South Africa and compare that with what happens in the United States. The conversation is being hosted by the Jesuit Institute in South Africa, based here in Johannesburg. We've all become aware of the word expropriation, certainly since President Ramaphosa signed the Expropriation Act in January of this year. And so it's really current. If we looked at the newspapers this weekend, we would have seen the Ministry of Energy showing the Minister of Energy, of Electricity, saying that if necessary, the government is going to expropriate land on which to erect 14,000 kilometers of new power lines and the associated infrastructure over the next 10 years. Then also in the same newspaper this weekend, we read about the draft Mineral Resources Development Bill, which envisages the expropriation of tailings storage dams, which are either not registered or not being worked at the moment. And then earlier last week, the Daily Maverick carried the story of an attorney in East London who had sold his farm to the municipality in 1999 because they had threatened to expropriate it. In the meantime, the municipality decided not to erect the municipal cemetery on that farm, and it took the farmer 20 years to win the case to buy back his farm. In addition, we're in an era of global land grab as people compete for water, for strategic minerals, for resources, and arable land. And government departments are not immune from this land grabbing tendency. Before proceeding, let me introduce this evening's speakers. I'll be hosting. My name is Peter Knox. I'm a member of the staff of the Jesuit Institute. I'm a Jesuit priest, and by trade, I'm a theologian. Our two conversation partners this evening are Mr. Mike Pothier and Reverend Fernando Saldivar. Mike Pothier is the programs manager at the Catholic Parliamentary Liaison Office in Cape Town. He's worked there since 1997. Before that, he was the coordinator of the Justice and Peace Commission of the Catholic Archdiocese of Cape Town. So he's worked for the Catholic Church for more than 30 years. He's also practiced as an advocate since 2000. Mike is married and has 4 children. Fernando Saldivar is joining us from London, I believe. He's a Jesuit scholastic, which in Jesuit terms means he's a seminarian on his way to being ordained priest. In fact, he'll be ordained priest on the 14th of June, so not this weekend, the following weekend. Fernando will be ordained. He's also practiced as a lawyer for several years. For part of his Jesuit training, he's kind of worked in Nairobi for a couple of years as an advocacy officer for the Jesuit Justice and Peace Network and Ecology Network in Africa. And he's been analyzing issues of justice, sustainable development, and poverty eradication, and formulated international policy as it affects us in Africa. Michael and Fernando, we're very pleased and grateful to have you join us this evening, and we look forward to hearing your insights and seeing the differences between South Africa and the United States. The evening will go as follows. Michael and Fernando will make presentations about the current and historical legislation in their respective countries regarding land ownership and expropriation. If we have the time, they will also address the colonial history of expropriation of the land from indigenous people and the issue of land being commodified and traded. By about 7:45, they will wrap up the conversation, and we will allow you, the audience, to share your questions. In the meantime, please write your questions in the comments box, the comments column, and I will address them to the speakers as appropriate. Your questions will have more chance of being aired if they are brief and not extended position statements. If we run out of questions in the comment section, then I will give you the opportunity, if there is still time, for you to raise your questions verbally by just pressing the reaction facility on your Zoom, the button for reaction. You can raise your hand, and then I'll ask you to raise your question. To respect your time, we hope to finish by 8 o'clock. So let's begin our conversation. Welcome, Mike. In February, you authored a briefing paper for the Parliamentary Liaison Office about the Expropriation Act. You called your paper "Making Mountains Out of Molehills." Would you let us know, please, what the Act is all about and why do you use this title, "Making Mountains Out of Molehills"? Thanks, Mike.
Thank you, Peter. Good evening, everybody. Maybe I can answer the second part of that question quickly first, and that is that ever since the Expropriation Act came into Parliament as a bill some years ago, people have become very excited about it, very alarmed, some of them, and have tended to exaggerate its scope and its possible impact. Some organizations, some opposition parties, commentators and so on have made out that this is some sort of nefarious means of grabbing land by the government, that, we're going to become another Zimbabwe, etc., etc. And none of that is remotely true. It's not possible in terms of the Act. So I suggest that they've been making mountains out of molehills when they exaggerate the possible effect of this Act. It's not a new piece of legislation in the sense that South Africa, like most countries, has always had a statute allowing the state to expropriate land for certain purposes. This Act replaces the Expropriation Act of 1975, for example, and that itself was not the first one on our statute books. And it's a very commonplace thing for governments and city councils and so on to forcibly take land when they need to build a new road or an airport or a dam or something like that. It's an everyday occurrence. It's happening right outside my window at the moment. A road is being widened, and the City Council of Cape Town had to expropriate a sort of 20-yard strip along the length of that road from various property owners. Some of them were happy to receive compensation, others contested it, wanted more money, etc. So it's communal garden stuff. What does set this Act apart, though, is that it makes provision for expropriation without any compensation being paid. And that's really the aspect of it that has set the cat among the pigeons. But again, it's rather exaggerated. The circumstances under which the government could expropriate land without paying compensation are extremely circumscribed. And if you'll allow me, I'll just mention briefly what those circumstances are, so that you can see that this is not the great monster that it's made out to be. Firstly, where land is not being used and there is no intention to develop it or use it in any sort of useful way, and it is merely being held onto so that its price rises and the owner can then sell it in the future. In other words, speculative land holdings. Such land could be expropriated without compensation being paid. Secondly, where one organ of state expropriates land already belonging to another organ of state, that's not very controversial. It's basically a book entry. If they did pay money across, it would be Peter paying Paul. So no compensation gets paid there. Thirdly, where the landowner has abandoned the land and given up their right to ownership, just as long as it's a voluntary abandonment. In other words, if they've tried to keep control of the land and they've failed, then it can't be expropriated. That takes care of things like land grabs and invasions and things, which we do have. But there are many buildings and pieces of land in our country where the owner can no longer be traced. They've given up. They're not interested. They're not paying property rates or anything. Such land could be taken, not necessarily without compensation being paid. And lastly, pieces of land where the state has already invested into that land more than its market value. That would be in some of our land restitution programs, for example, where the state has poured in a huge amount of capital. It's gone to waste. It hasn't been used by whoever the beneficiaries were. The state could take back that land without paying compensation. Of those four categories, Only the first mentioned, I think, is controversial, and it might well be struck down as unconstitutional because speculative landholding is not illegal. Some people do that. It's a business for some people. I think it's unwise that they've included that in the Act, and I think it will end up being taken out by the courts. But you can see from that brief summary, it is only in those very exceptional circumstances that no compensation could be paid. And just to finish on this, Peter, even then, that would have to be approved by a court. Anybody faced with such an expropriation where the state proposes not to pay them compensation, in terms of the Act, can go to court, make their argument, and the chances are that if it is an unfair move, the court will come to their rescue.
Wonderful. Thank you very much for that very good summary, Michael. I think you make it sound very fair, and there's always the protection of the court, a person being able to have recourse to the courts. Fernando, may I ask you, in the United States, you have this clause called eminent domain, which is in the Fifth Amendment of your Constitution. This clause allows the government to expropriate property with fair compensation. Can you tell us what this is about, please?
Of course, and thank you, Peter, for inviting me here this evening. Um, I think the question for us poses something interesting. It's that we're here tonight speaking about expropriation and I think part of the reason why we're also here tonight is in response to, um, dare I say it, the stunt that President Trump threw in the Oval Office during the state visit of President Ramaphosa and several others. And it's given the impression that expropriation is something foreign to the American legal system, is something that doesn't exist among one of the powers of our government. And that's not at all the case. We have expropriation. We simply call it something different. We call it eminent domain. And in American law, there's other ways to refer to the very same concept, the very same idea that we're talking about. It can either be called eminent domain, it's often called takings, government takings, uh, condemnation, condemnation proceedings. That's another way of referring to the same thing. But we're talking about the very same concept. We're talking about expropriation. And anytime, particularly, that you might hear in the American media something different, that expropriation is not something that happens in the American context, that's simply not true. It's more than an issue of semantics, but the fact that American governments, and I say that in the plural, do this is part and parcel of our system. And let me get into that just a little bit more because it may be helpful if I give just a little bit of American constitutional history, how this all looks. Um, and part of this is that the Fifth Amendment of the Constitution, as we're referring to that, refers to the Fifth Amendment of our federal Constitution, of the Constitution which establishes the federal government, which is based in Washington. And in the American system, there's a separation of powers between the executive, the legislature, and the judiciary, and our constitutions describe all of that. In our system, however, there's also a separation among sovereigns. So there is a separation in the sovereign power held by the federal government and that held by the states. So one key thing to bear in mind is that next year, the U.S. will celebrate its 250th anniversary of independence, the date it declared its independence from the British Crown. That date precedes our constitutional system. So the federal constitution was drafted after independence was achieved. It was done by many of the same people, but it follows later in time. And so the key part to remember there is that the states, the United States, the 13 states at that time, precede the federal government. Therefore, the federal constitution is a delegation of powers by the states to this new federal government, which means that the federal government is in actuality limited. It's a limited government. It can only act within the parameters of the federal constitution. It's not a full sovereign. The states, on the other hand, are full sovereigns. They hold all of these plenary powers, ranging that we would think that governments normally hold. So there's at times a struggle between those two, and that part was important because all of the amendments that follow from the federal constitution are refinements on the federal government's powers, what it can and cannot do. And so, when the federal constitution was being ratified by these same states, many of them had a problem that there was not a Bill of Rights there. There wasn't a delineation of what the specific rights of new American citizens would be. And as a condition of ratification, several states demanded that the first thing that would happen was that a Bill of Rights would be enacted or would be suggested. And the first 10 amendments that were suggested became the American Bill of Rights. And the fifth of these is the one we're talking about right now, where a certain limitation on this eminent domain, this expropriation power of the federal government is laid out. And it's there. And in the Fifth Amendment, which among other things discusses several things related to criminal procedure and what the kinds of evidence that can be involved, at the very end, almost as a caveat, there's an addition. And it says, one of the limits on the federal government's power is that private property may not be taken for public use without just compensation. And so that there is the limit and the scope of the federal government's expropriation power. Now, there's a key point to remember with all of this that I've just described. The federal constitution is a limit on what the federal government in the United States can do. This limitation did not at the outset apply to the states. They had a full range of powers of expropriation that were not limited by that. And this is important because the US Supreme Court in the year 1879, so quite a while ago, recognized as a principle of US constitutional law that eminent domain, expropriation, quote, appertains to every independent government. It requires no constitutional recognition. It is an attribute of sovereignty. And what that means is that in American constitutional jurisprudence, the right of expropriation rests with the sovereign. There is no need to enumerate this. It is the right of a sovereign state to have this power. What the Fifth Amendment does is that in the US federal system, it limits that. It says that yes, this power exists. This is the power of the sovereign. However, it can only be exercised for a public use and with just compensation. So, in a way, the American system recognizes that free governments, sovereigns, independent states have an inherent right of expropriation. It's then the ability of these same states, as the Americans have done, to enumerate limits to that. And that's in fact what the American system recognizes, that a government in our system at all levels, whether it's the federal government, a state government, or in fact a state government in our system, can delegate that to municipalities, can delegate that to lower tiers of government, this same power. But with the federal government, at least, it's limited to a public use and with just compensation. That public use part is key because the states do not have that same limitation. States in the American system can exercise eminent domain. They can expropriate, if you will, for a private interest. They can expropriate on behalf of private interests and delegate that and exercise this authority on behalf of private entities. And so, in practice, how that works today is that expropriation, or eminent domain as we call it, is exercised by state and local governments for redevelopment purposes, to clear blighted areas, to clear certain areas in urban centers that are blighted. And this can be done by private development organizations, private organizations approaching state government, making an argument, and then the state government exercising that right on vis-a-vis privately held property. Where that is limited today, and there's no need to get into this, is that that same Fifth Amendment requirement that there be just compensation has been interpreted over the years to now apply to the states. So even at the state level, even though land and property can be expropriated for a private interest, it still needs to be with just compensation. And in the US today, at all levels, this is where the fight is for the most part over the amount of compensation, because although we can no longer, I say we collectively as American governments, cannot expropriate without compensation. That's been established. Determining what that compensation is where all of the fighting takes place today. But to argue and say that we don't have it, that we don't have governments in the US don't have the power to expropriate, is simply not true. In fact, this expropriation power is read so broadly that it applies to property across a spectrum. It's not just land. It can also include property rights in intellectual property, such as patents, copyrights, contract rights, all those other things. Those can be expropriated. And I'll end with this part. In the American system, there is uh, a development in this law where, in a sense, we call this inverse condemnation, which is where an action by the government which affects or has a negative impact on some property interests that you hold, you can now sue the government for compensation. So, in a way, it works both ways. But the fact of the matter is, in all of this, anytime we're talking about eminent domain, we're talking about expropriation.
Thank you very much indeed, Fernando. It's really good for us to hear from South African point of view that this is not something kind of wicked that the South African government is doing, introducing, whereas you simply have a different terminology for the same thing that we're talking about. The difference, as I'm hearing it, is that in South Africa we have the possibility, and Mike outlined those four possibilities in which there may be no compensation, whereas in your system there is always compensation, just compensation. Mike, in your position paper and in the Act, of course, it mentions public interest and public good. Can you distinguish those two for us, please?
It's public interest and public purpose. Those are the
Public
two.
purpose, public
Yeah.
purpose.
So what it comes down to is that expropriation can take place, expropriation with full compensation of any property, as Fernando mentions. It can be things like rights, patents, etc., intellectual property. It could be movable goods, equipment, vehicles, etc. If it is necessary for a public purpose, something from which the public will benefit. In fact, it's almost always land. I'm not aware in our legal history of the government, either the present democratic government or the previous apartheid government, having expropriated stuff that was not land. It may have happened, but I've never seen any report about that. One can imagine, for example, wartime, when we used that expression commandeering in an emergency situation, taking over people's vehicles and so on. That's a form of expropriation of movable property. But nevertheless, there must be a public purpose that is met by this, classically, the roads and the dams and so on. Public interest is a different category, and that's defined in our Act, particularly with reference to our history of land dispossession under apartheid, where, as we know, hundreds of thousands of black people lost their land as a result of the apartheid architecture and the homeland system and all the rest of it. It is deemed to be in the public interest that we have land reform, where we have land restitution, giving people back land that was taken under apartheid. It's important to notice that expropriation without compensation can only happen on public interest matters, not for public purposes, and only of land. So if the government ever decided that it needed to take someone's intellectual property or someone's vehicle or someone's wine collection for whatever reason, if they could overcome the hurdle of having to show that that was in the public interest or for a public purpose, they would still have to pay compensation, because it's only land for which, under those narrow circumstances, they don't have to pay compensation. And I should mention again, as far as I can tell, the nil compensation situation would only be in circumstances, in effect, where what the state is trying to do is to redress a past confiscation of land, as I say, in the apartheid era. I should also add, Fernando was mentioning constitutional provisions and so on, that all of this is subject to our own constitution. And amongst other things, our constitution demands that administrative acts by the state, and expropriation is certainly one of those, must always meet the tests of reasonableness and justifiability. They cannot be arbitrary. Our government simply cannot wake up one morning and decide that it wants your thing and take it. It's got to be an administratively reasonable process. It's got to be justifiable in terms of constitutional values and people's rights, etc. And above that, it must also serve the public purpose or the public interest.
Thank you. Thanks very much, Michael. David Lipschitz put up a little comment in the chat. I said it was not only black people, but also colored people in District 6. And I certainly know of white people who've had their farms expropriated in KwaZulu-Natal. Well, it was Natal at the time, in order for KwaZulu to be built there. So, I mean, this land expropriation was taking place across the board in South Africa. So thank you very much for that clarification there, David. Mike, you wrote to me that you're very interested in Catholic social teaching. What's the Catholic social teaching with regard to land ownership and land expropriation, please?
Well, there's quite a bit of it. I mean, one can just simply refer to some of the central principles of Catholic social teaching and see how they relate to land ownership and also possible expropriation. So the principle of the common good obviously resonates quite closely with what the Act talks of as the public interest. The common good of society, in that sense, is superior to individual needs. So that would be one way in which a central Catholic social teaching principle applies to land and the need that the community through the state may have from time to time to take that land for a public purpose. I think one could also argue that solidarity is another central Catholic social teaching principle comes into the picture, because you are invited, if you like, as the owner of the property to give it up, hopefully against proper compensation, to be in solidarity with the needs of others. If there is a need, for a community to build a dam and they happen to need your stretch of river to build it on and so on, you are showing solidarity with everybody else by allowing that to happen. Probably most pertinently in CST is the teaching of the universal destination of goods. So the Church has always held that while it defends private property and very, very strongly defends the right to private property, all property, goods, including land, ultimately belong to the community as a whole and must be at the service of the community as a whole. So if I can quote, for example, from Vatican II, Gaudium et Spes, it says, and I'm going to try to make this a gender inclusive language, which is not how it was written originally. In their use of things, people should regard the external goods that they legitimately own, which could be land or anything else, not merely as exclusive to themselves, but common to others also, in the sense that they can benefit others as well as themselves, the owners. That's one such example. There is also, strangely enough, a direct reference also from Gaudium et Spes to expropriation, which says that whenever the common good requires expropriation, compensation must be reckoned in equity, so fair compensation must be paid after all the circumstances have been weighed. So interesting to find the bishops in Vatican II directly addressing the question of property expropriation, linking it to the common good, and then saying, yes, there must be compensation, but in equity after all the circumstances have been weighed. And that's in effect, I would argue, what our act is doing. It's saying you can take into account all the circumstances, how the land was acquired in the first place, whether the land was acquired justly or, for example, as the result of apartheid, encroachments of various kinds, what the land is being used for now by the owner, if it is being used at all, or it's been abandoned, what it's going to be used for in future, how much money the state may already have invested in that land. So that's weighing inequity, as Vatican II put it. So plenty of social teaching relevance, I think, and guidelines for the question of property expropriation.
Thank you. Thank you very much, Michael. Could that be a response, so the bishops, could that be a response to kind of the communist kind of taking away of land and sort of communalization of property and things like that, which had happened before the Second Vatican Council, between the First and the Second Council? Is there a basis or a reaction against communism there?
I'm not, there may be, but I'm not quite
Okay.
sure that that's the case here. I think that
Okay.
it goes back further than that. In fact, there's another interesting document from the Pontifical Justice and Peace Commission published in 1997, which they called Towards a Better Distribution of Land, where they looked in particular what they call the latifundia, the massive agricultural estates in Latin America, which are always a great bone of contention. And there they trace this social teaching on land way, way back. They quote Thomas Aquinas, for example, and his teaching about people in desperate circumstances are allowed to take for themselves the property of others. Again, the universal destination of goods. In dire circumstances, people can take other people's property if it's a matter of survival. And I think that that's the history of the social teaching on property. And let's face it, land is, in the sense, for our purposes, merely one form of property in that sense.
Thank you. And I mean, you just mentioned the word latifundia. I remember when I was in theology, studying theology, that term goes all the way back to the Old Testament times and it's part of the wisdom literature that people are allowed to start using farms from which they've been evicted or whatever. So it's not, I mean, it's not only kind of during Latin American or kind of the time of colonials, but it goes back to the Old Testament as well. Thank you, Michael. Fernando, you took us back 249 years to the writing of the Constitution, the 13 states that existed before them. Could you take us back perhaps to the 15th century and the situation of settlements of the European, that wave of 15th century settlers who arrived in the United States? What was the relationship between native people and the land? And has this changed? And are there moves to kind of assert native ownership of Aboriginal lands? Please,
Thank you,
Fernando.
and it's an excellent question, but I want to preface it by also saying that as I think we're touching on here, vis-a-vis the question of land reform in South Africa, the question of dealing with the unjust distribution of land from an earlier time, from an earlier government, that effects are still felt today. That's still very much the case in the United States as well. And, what President Trump may want to think and otherwise, the question of land distribution, the question of ownership of land, questions of property in the United States are inherently racial. They will implicate our racial politics, our history, and the fact that so much of that is unresolved. In fact, what makes much of President Trump's agenda so appealing to the sector of our population that he appeals to is the very fact that he touches very quite a few of these raw nerves that still exist in our society. Because even on the question of land reform, um, the United States itself is desperately in need of a land reform, or at least even to acknowledge, whether it's in the form of even, say, for example, a Truth and Reconciliation Commission over what happened vis-a-vis our own history with slavery, our own history of conquest of native peoples, and another part of our history which doesn't get quite played up enough, the fact that in the 1840s, just to go back to the 19th century for a moment, the United States at the time fought a war of conquest against Mexico. And as a result of that, obtained a third of Mexico's territory. So the entire West Coast from the Southwest into reaching from Texas to California became part of what would become the United States and its national territory as a result of that war, which means that anytime you're talking about land, especially distribution of the lands in the West from the U.S. perspective, you're implicating not only the relationships that were there with native peoples, but also the relationships with what would become with the conquered people, with people that were one day Mexican citizens and were now part of this new American Republic. And there's problems there that come with that as well, because again, you're dealing with uh, questions of land tenure, questions of disposition of land, property rights, marital rights under a legal framework that comes out of the Spanish world and one that comes out of Anglo-Saxon common law. And they're very different at times. How do you resolve these things? And to even bring in native peoples, American Indians, with their own systems of how land is held, and particularly how it's held collectively, how it's held by the community, and how it can't be divided or alienated in the way that we think. For example, the idea that you can subdivide and parcelize property to many of the native communities that are within today the United States was entirely a foreign concept. And one of the things that the United States Supreme Court did very early on in the 1820s, in fact, and this actually touches very relevant questions of Catholic social teaching, is that the U.S. Supreme Court recognized the right of discovery. It recognized that by applying European standards of what it meant to discover territory, as a result, to come back to the question of the sovereign had inherited rights over people that didn't have these same European concepts of property. So, for example, the United States has appropriated for itself all of the rights that at one time the British Crown claimed over the entirety of the North American territory. Case in point, in the Treaty of Paris, which ended the War of Independence between the United States and Great Britain, the Crown specifically ceded to the United States government any and all territorial claims and basis for those claims that it had over all of the Native American populations that it discovered. As a result of which, to this day, the U.S. federal government claims sovereignty over these same Native American tribes, which means that in the United States, all policy vis-a-vis American Indians, their uh, uh, in their lands, and as a result, it's the federal government that exercises a complete sovereignty over that. This could easily be the subject of a whole different webinar, just how this works. But the fact that these same tribal governments to this day have no recourse over the federal government. It's the US federal government that determines what is in their best interest or not. And all of this too implicates land ownership. Again, because the extent to which tribes can hold property, alienate property, to this day is determined by the US federal government in a way that it's not for US citizens, US residents who are not of American Indian background. And it's just one more example. And I haven't even touched, the ways that former slaves in the US were not given land upon emancipation. And from that moment, establishing a different racial dynamic to the manner in which land was held in the United States that is neuralgic to this day. So I think the point that I just put with all of this is that to this day, even though de jure racial segregation and many of our worst examples of race-based legislation no longer exist, the effects of this are still being felt today and rather sharply.
Thank you very much for that, Fernando. I'm sure many of us were hearing echoes of our own South African history in that as well. I'm very interested that in Australia they had this doctrine. The British came with the doctrine of terra nullius, and I'm sure that's possibly what was going on in the United States as well, in South Africa as well, or wherever the Brits established their colonies, that the land was regarded as completely empty and available for the Crown to take. I'd come to the question more from the perspective of Laudato Si, of kind of the land itself. Does the land have any right not to be owned, not to be commodified, not to be traded? Does land have its own rights? I know there are movements in Canada, in New Zealand, in China, in Ecuador, in parts of Western Europe, where people are saying, what does the land want? What would the land, if it were a legal person, what would the land actually desire? And are there any, in South Africa or American law, are there any clauses where the land is given legal personhood, landscapes perhaps, or particular rivers, or particular sections of land where the land's interests are fought for or are defended simply as land? Let's start with Mike, and then Fernando, maybe you might have something to add to that as well, please.
I'm not aware that there is any, there certainly are no legal provisions in our country providing for the land to be a bearer of rights. And I don't really see how it could be, since the land can't speak for itself. What we would have in effect would be that various interest groups would be speaking or claiming to speak on behalf of the land. They would be sort of imposing their own views, and one lot would say the land desperately wants to be farmed and turned into a wine farm, and somebody else would say no, the land really feels that it should be left fallow, and so on, or to be grazed by sheep. I'm not that enamored of the idea that we can project our understanding of rights onto an inanimate thing and then claim that that's what the inanimate thing wants. Who knows what the land wants? No one knows what the land wants. I know in Ecuador they have recently passed legislation to give legal personality to a river. Again, I'm skeptical about the practicality of such a thing. There's certainly, in our constitutional setup, I can't see any scope for that. And I think it would be highly contestable if it were to happen. It's a bit different. It's a bit easier to think of animal rights, if you wish. I know at the moment there's a big move on internationally to give whales human rights as a way then of people being able to go to court on behalf of whales against their slaughter. But even then, note that we are projecting our ideas onto the whales, and we then go to court to protect them. It's not actually the whales that go to court, evidently. So these are really just, I think, human rights, which we project onto uh, animals and inanimate objects to serve our own purposes and understandings, which may be good purposes and
Mhm.
understandings, but I don't think we can really claim that the earth can be the bearer of rights itself.
Okay, thank you. Okay, I'm hearing that Pope Francis speaks about kind of rampant anthropocentrism. For example, we do what we believe that the whole world is there for our use, and kind of the protection of landscapes or the setting aside of landscapes simply to be what they are. Um, and that's the whole conservation movement, which has been around for 1.5 centuries. That still exists, but to ascribe legal personality, you're saying that doesn't make sense at all because interest groups would then claim to be speaking on behalf of that legal person. Fernando, do you have anything to say about the situation in the United States, please?
It, the, in the United States in particular, it's uh, there's interest in this, and there's move there. Of course, there's actors who would like to do this. It's to do something in vis-a-vis ascribing legal personhood to elements of the natural world, it'd be an uphill climb, and it's there's that. But there's something interesting about the particular locations that you mentioned where this is taking root, particularly in the Americas. You mentioned Canada and you mentioned Ecuador, and
Ecuador.
these are two places that are very, particularly in Ecuador. A country with still a very, very large indigenous population. And particularly in the indigenous practices of the Americas, um, there's an enormous, this type of perception that you can ascribe personhood to natural uh, to things in the natural world, lakes, trees, land itself, is part and parcel of that spirituality. And I underline that because it kind of begs the question, if you will, where is that line between spirituality as spirituality and law, uh, rights-bearing entities as we've come to understand it? And I don't have an answer for that, but I think it's something very, there's something profound there, uh, particularly in the American context, where the arguments like this have come up is in land use cases involving Native American tribes. In fact, there's a case going on as we speak where the Apache peoples in southern Arizona are fighting against a new mining operation at what an area that they call Oak Flats, and it's a sacred site to them. And they've tried many of these arguments, and they're hitting brick walls again because they're just run into black letter property law. And it's like yes, we understand that this is important to you. However, as a matter of right, this is land. It can be alienated, it can be bought, it can be sold, with all of the disadvantages that I've already underlined of how Native peoples in the U.S. Native communities are treated by the federal government. Um, I think there's another question tied into this, and it's actually one step back. It involves this concept of legal personhood. What does it mean to be a person? What does it mean to ascribe personhood to entities that are not themselves human beings? And I think there's a very interesting, very profound reflection to be had there with many of the documents and many of the reflections that Pope Francis has left for us, which is, I think, one of these next areas crying out for attention from theologians, from those who are engaged in Catholic social teaching, because particularly in the US, where the courts have recently, relatively recently, said that a fictive person, a corporation, can have religious beliefs. What does that mean? What does it mean for a corporation as a corporation to have a religious belief. We haven't figured this out, but we're not talking about it either. And I think there's so much here that we could be talking about.
Thank you so much. Yes, fictive persons.
Mhm.
Um, yes, that's very interesting. We don't use that term here in South Africa. Louis Tsuro has replied to this question about land itself having rights, and he says he would be much more interested if the conversation went in the direction of giving recompense and seeing the trajectory of disownership and well, not disenfranchisement, but so people losing their rights to ownership and our whole land, as you've pointed out, both Mike and Fernando, you've pointed out that our land question in South Africa is about restoring rights, restoring dignity, restoring people's ability to say, I own something which is fungible, something with which I can actually trade and sort of something that gives me some security. We see that both in the United States and in South Africa. People need something which gives security. Do we have anything to say to that, or would you simply confirm what Lewis is stating here? Mike or Fernando? Mike?
Yeah, I agree that we need to have that discussion. We can't just draw a line, an arbitrary line in the land, in the sand, as it were, and say, well, we're not going to think about the history of how this land was acquired. We're only going to think of the present circumstances. Um, any amount of land in this country, obviously, the majority of land that's now in private hands, was acquired one way or the other by conquest, by settler colonialism, and other mechanisms like that. It has to be said, if we go a bit further back in history, not a couple of 100 years, but 1,000 years or maybe more, that the Aboriginal people of the southern part of Africa, the San, the Khoi, etc., had large parts of their land taken from them by Bantu-speaking people moving down from Central Africa, going back, as I say, a couple of 1,000 years. How far back do we want to take this investigation? How far can we compare Western-style title to land, the idea that I own this particular patch and I've got a title deed to show it, with more indigenous ideas of communal and almost transient ownership or possession of the land as people moved from one part of the country to the other, leaving land behind them maybe for many, many years as they followed herds or they followed the rain or whatever. I'm not sure how we have this debate. It's a very complex one. But I am sure that we can't simply say that, look, we're now in 2025 and we must take the land ownership situation as it is today and hold that to be sacrosanct. We can't do that. We've got to take account of our history somehow.
Thank you. That takes us to quite nicely to what Kevin Johansson has just put in the chat box. The idea of Jubilee was that every 50 years there would be some kind of restoration. Slaves would be liberated, land would be returned to families, people who'd been sort of moved off their land in kind of, Kevin cites here the book of Malachi, but I'm sure we see Jubilee in many of the Old Testament books. And the idea of the Catholic Church celebrating Jubilee every 25 years is to try to readjust or to try to bring things back to a workable situation. We remember the Jubilee of 2000, where there was big move to cancel odious debt or to cancel very heavy debt. Can something like that work relating to land? Fernando, Michael?
I think it could, and I think and it's not to say that would be easy, because part of that is it's a change in perception, it's a change in mentalities, and I think this is one of those ways, not even perhaps, But it's the fruit of what Pope Francis left us in Laudato Si. That is still such a tremendously powerful document with so much that remains to be unpacked. And in a way, one of the reflections I think this invites us to is thinking about what Francis described as integral ecology, this idea that everything is interconnected. How do we apply that to how we think about land? How do we think about land in that way that crosses borders, that pays regard to the debt really that collectively we have to the poor in every region of the world. And I think land and land distribution is such a critical way about this again because the manner in which land was and is distributed in the United States has effects not just within our own country, but worldwide. And it's a question of changing our perspective to that global vision, which admittedly is difficult, but so necessary.
Thank you. Thank you very much. Mike, do you have anything to say about that?
No, and I don't
Okay.
think I want to add anything to what I said previously. No.
Right. Okay, thanks. You've responded to a question in the chat about expropriation as it happened in South Africa. Um, where is that now?
But
All expropriations are subject to review, and if the owner is unhappy, then compensation,
no,
the owner has to be happy with the amount of compensation offered. If we go back to that state, well, the situation that happened in East London, where the farmer's land was expropriated,
mm,
and ultimately the East London municipality didn't use it for the purpose for which it stated it needed the land. It took 20 years. Are you, Fernando and Mike, both confident with the judicial process? Are you kind of, I mean, 20 years, they talk about justice delayed being justice denied.
yeah, yeah.
Um, if there are rogue players, to use a term here, rogue municipalities, is there a certain arbitrariness? I know the act tries to prevent that, but is there room for arbitrary kind of behavior here?
No, it's not arbitrary behavior. I haven't studied that case in particular. I did read one news report about it, and it appears what happened was that the local authority in East London legitimately expropriated that
Mm,
land, paid him compensation with which he was happy at the time. It was a market-related price, and they said, we're going to build a cemetery. And then, of course, they failed to build the cemetery for some years and some years. And after quite a long period, he decided, well, actually, if it's not going to be used for that purpose, I'd quite like it back. And he then negotiated with the municipality, and they suggested a price which they thought, took into account increased land values over the interim period, et cetera, et cetera. It was a much higher price. And I don't think he was particularly happy with that. But the key point, Peter, I think, is that the expropriation process there was not controversial. It happened according to the law. Compensation was paid. All parties were content with the process. It was only because down the line the state entity failed to use it for the purpose for which they had made the expropriation that, he could then go back to court and say, look, I want this land returned to me because it's not being used for that purpose. And the court sided with him and said, in effect, this from an administrative law perspective was not correct and you must have it back. But then he had to pay. He had to pay the municipality, not necessarily their full asking price. So in a sense, that wasn't really a question that legally around the expropriation side of things, but rather about the subsequent use or the failure of the municipality to use it as intended.
Okay,
And just if
thank you.
I
So
may say about the rogue players notion, the notion in the chat box that rogue politicians could misuse or abuse this act, it simply is not possible. Politicians can't enforce expropriations. That's done by organs of state, government departments, municipalities, and so on, according to the law. And it can only be according to the law. There's no way that individual politicians, rogue or otherwise, can employ this act for their personal purposes or political purposes. And if if they were to try, hypothetically, a court would throw it out immediately.
Okay, thank you, Michael. I mean, that's reassuring. The part of the problem in this case was that it took 20 years, more or less. We're coming up to 1 minute to 8. I told our listeners that we'd be finished by 8. I'd like to take the opportunity to thank you very much, Fernando, and you, Mike, for joining us, for enlightening us, for allowing us to discuss and possibly be reassured. I hope we've come away, at least the South Africans in the room, have come away with some reassurance that there's nothing arbitrary. It's all under constitutional guarantees, and second point of reassurance, that something similar exists in the United States. You don't have, in Fernando's case, he made it very clear, you don't have the possibility of expropriation without compensation, but at least there's a similar case of expropriation in the United States. We're very grateful to all of our listeners this evening. Thank you for joining us. And thank you, Fernando and Mike. Fernando, we'll pray for you on the 14th of June for your priestly ordination. Fernando and I have known each other for some years, and it's very good to see you arriving there eventually. It's 8 o'clock. Thank you, everyone. Good night and God bless.